Welcome to our webinar today. Thank you so much to everyone who is joining us on exploring these new frontiers with Title IX. I'm Dr. Laura McGuire from the National Center for Equity and Agency, and joining us today is Dr. Felice Duffy and Elizabeth, and they both are going to give us a little more information about themselves and the unique perspectives that they're bringing to this conversation. So Dr. Duffy, can you begin by telling us about your background, how your work intersects with Title IX, and your full name and pronouns, anything else you'd like the audience to know about you?
Yes, thank you, Dr. McGuire. I appreciate your asking me to be on this panel. This is a really important time for secondary schools, colleges, and all educational programs with respect to these new regulations, particularly within the realm of the pandemic and how they're adapting to all that. My name's Felice Duffy. You can call me Felice. With respect to Title IX, I've been involved in Title IX. I'm going to date myself here since the 70s when I was a student at the University of Connecticut, and I filed a complaint with the Office for Civil Rights to get a women's soccer team there under Title IX, and we prevailed. We ended up being third in the country when there was very few teams in the country. I went on to be a on-paper member of the U.S. national women's soccer team very early, and then coached at Yale for 10 years as a Division I head women's soccer program during a time in which Title IX was really being rolled out in colleges and universities across the country. After that, I got my law degree, and I worked in a number of different firms, was always interested in discrimination and civil rights, ultimately became a assistant United States attorney, which is a federal prosecutor for 10 years, where I assisted federal law enforcement to keep communities safe by prosecuting violent crimes, drugs, large drug trafficking organizations, and gun violence in Connecticut, mostly in Bridgeport, New Haven, Connecticut. The last 3 years of that, I was one of the reentry coordinators for the Obama and Joe Biden administration when they rolled out the new requirements regarding Title IX in 2014 through the White House Task Force. I assisted the District of Connecticut by advising schools with the help of OCR and DOJ in educating them about exactly how and what they're required to do with or without the assistance of the Office for Civil Rights. I left the U.S. Attorney's Office in 2015 and opened my own firm, and I was doing federal criminal defense and Title IX, and ultimately my clients are clients right now. I have other people doing federal criminal defense because there's such a need because of the what's going on right now with respect to sexual harassment and sexual misconduct on college campuses. And I have represented both complainants and respondents, students, faculty, and staff at a number of different colleges and universities across the country, as well as some high schools. So thank you.
Fantastic. Yes, thank you so much for joining us. And I can't wait to hear your perspectives on a number of these new arenas that we're going into. And Liz, tell us a little bit about yourself.
Sure. So, hi, I'm honored to be on this panel with you all. My name is Liz. I am a junior consultant at the National Center for Equity and Agency. So, I was a journalism major and a student survivor of sexual assault. So my perspective on Title IX is actually one that involves going through that process on a college campus before some of these regulations were rolled out. So I was an advocate on campus for survivors, and afterwards realized that I needed to continue being an advocate, and I was a hospital advocate in Nassau County, and then I became an educator. So I go and I am able to speak to high school students and college students about consent and healthy relationships. And I realized again that there needs to be more done than just speaking about it. So I went back and I received my master's in public policy so that I can make a larger scale change. And that's my plan here, is to prevent sexual violence before it happens and support survivors if this crime does have to happen to people. So yeah, I'd be happy to share that experience of going through that Title IX investigation. And actually, ironically, it turns out that the respondents in my case did end up suing the university, and I went through that Title IX case recently, and it looked a lot differently. And so I think that I have a pretty broad perspective on how these issues work as a survivor, as well as becoming an educator and becoming extensively trained in these topics to help others. So yeah, thank you.
Awesome. Well, thank you for joining us. And you also currently do additional work with a local nonprofit on Long Island doing prevention education. Is that correct?
Yes, exactly. So I work at a nonprofit on Long Island where I am able to be an educator in the high schools in Nassau County.
Wonderful. Awesome. All right. So Dr. Felice, can you tell us a little bit for anyone who's watching and, maybe has just gotten into this field, or they're a parent, an educator, they want to understand more. Tell us a little bit about where we went from 1972 to the 2011 Dear Colleague letter to today. What have been obviously that's a huge story, but what have been some of those leaps, right? Because people might be watching the news and seeing, wow, there's been these drastic changes, but they don't really have any context for what that means.
So very generally, because I could do a 3-hour seminar packed just on that question. But very generally, back in 1972, when President Nixon signed into law Title IX, it actually, many people think it developed out of a sports case, but it actually developed out of a sexual harassment case. In 1975, and this is important because these current regulations are all about the notice and comment period and what makes them binding versus not binding. In 1975, the Title IX required schools to have within 3 years, by 1978, file a self-evaluation showing how they're not in compliance with Title IX and how they will be in compliance by 1978. And a lot of this focused on sports. And I will just say as an aside, there was 9,700 public notice and comments from everybody about sports because nobody wanted this to apply to football. That's been a prevailing problem. And I will say with respect to athletics, ultimately, senators got Title IX not to apply to athletics. And it wasn't until the 1987 Civil Rights Restoration Act that it went back and applied again to athletics. So there's always been a lot of controversy about Title IX and who it applies to. Up until the late 2000, a lot of it was focused on sports. You could ask anybody probably about what Title IX was, and they would talk about sports. In 2011, the Office for Civil Rights, which is the agency that enforces the Department of Education's law, which is Title IX, they sent out what's called a Dear Colleague letter, and the Office for Civil Rights provides guidance to people about different laws and how they affect, whether it's disabilities or racism. And in this case, Title IX is gender discrimination. Educational institutions are prohibited from treating one gender differently than the other in any educational program or activity. They'd had some rules and some guidance. In 2001, there was guidance from the Office for Civil Rights that was about sexual harassment and who it applied to. And that actually went through the notice and public comment period. So that is binding. After that, the Dear Colleague letters and any other letters that came out are only considered advisory. And that's why these regulations today are considered binding, and they're very, very important. Binding in the fact that they have the effect of law. And this has absolutely changed the landscape with respect to how schools are looking at these regulations. In 2011, that's the big Dear Colleague letter that really started to change the landscape. That was based on a lot of research that showed that one in 5 women on college campuses was sexually assaulted. And again, you got to look at this research and that a lot of people weren't reporting it. So that's only really reported cases of sexual assault. And there was basically, from my perspective, I'm just going to conflate this, a culture on campuses that really didn't permit women, because of our culture, because of what they call the rape culture, didn't permit women easily to report this and didn't help them and assist them through the process. Maybe schools weren't equipped to do that, but they really did not help women report, did not make it a friendly environment for women to report this if there was any type of sexual misconduct or sexual assault. In 2014, President Obama created the White House Task Force based on a lot of research about this, and they actually developed a website called You're Not Alone. They came out with a report and they made some stricter requirements for schools. And the requirements broadened the definition of what sexual harassment and made clear that sexual assault and sexual misconduct, which was basically unwanted sexual touching, was not allowed and violated Title IX, which the schools were required to look at. But they also implied, which every school's pretty much adopted, an affirmative consent standard. It's very different than criminal law. It's very different than anywhere else. Criminal law is a very different standard, but basically affirmative consent generally, because every school gets to define their own, but generally says that that somebody must get consent, whether verbal or by conduct, but affirmative consent at every stage of every part of sexual activity. So if you're about to kiss somebody, you got to ask or know they want to somehow. It has to be unambiguous. And that means every single time you go through and switch an activity. Very different standard, but most schools implemented that, and that's what the Obama administration was looking for. They also said that it was going to be by a preponderance of evidence that schools were required to take complaints, and if any school knew or should have known that there was a possible violation of Title IX, like if you're in a locker room and you overhear an assistant coach talking about, a party where they heard somebody, was sexually assaulted, they were required to report it to the Title IX coordinator. And even so, if they didn't, the school was liable for not investigating it. Very high standard. Schools were required to immediately investigate this by a preponderance of evidence, which is a featherweight over 50%. They're required to have procedures. Each school could do their own, so no one really got a lot of guidance from the Office for Civil Rights about exactly what to do, but they were required to follow them. Schools, the Obama administration was advocating for a single investigator model, meaning that one investigator would do interviews without the parties in the same room to protect everybody, go back and forth, create a report, make a finding of responsibility, and then either that person or perhaps another person would then determine whether or not they were responsible. This means there's no hearing. Schools could do hearings, schools all adopted different things, but that was the model of the Obama administration. After that, in 2016, I believe it's the Violence Against Women Act and the Clary Act, along with many state laws, also added sexual assault, stalking, intimate partner violence, and dating violence to these crimes with additional regulations about them. And crimes is not the right word for me to use, to these violations with additional regulations for each school to really take a look at those. Mediation was not permitted in any of those 4 types of cases. You're not allowed to do that. You could have an informal process, you didn't have to, but you could, or you could have a formal complaint process. After that, it was actually, there was a lot of news, a lot of national news that I'm sure everybody's aware of. A lot of women felt more empowered, and I'm going to say women. Complainants can be male or female, but I refer to, for the sake of simplicity, I will say women, maybe for women complainants, or I'll call them complainants. But or survivors, there's different words, so I want to be, it's a very sensitive topic, so I don't want anyone to feel bad, because I think that, there's a lot of legitimacy to everything that's going on here, and I don't want anyone to feel minimized by the legal aspect of what I'm talking about, because I think it was a really important thing to bring this to light, and I think it was incredibly important to shift the culture where women complainants or any complainants were not really reinforced for bringing forward those complaints. But after that, the Office for Civil Rights, for the first time ever in 2016, held in favor of a male responder that the school had not actually followed Title IX. And it shifted from women feeling more powerful and more reinforced to bring complaints, and they were, to people saying that the accused males basically weren't giving due process, and a lot of lawsuits, which Liz, I know you said you were involved in one, but a lot of lawsuits were filed after that. So it went from very supportive for complainants to accused saying that there was not due process, and now there's a lot of activity on both sides. And unfortunately, it's been polarized, and people either take the side of the complainant or they take the side of the respondent. And in 2017, Betsy DeVos, as the Department of Education Secretary, it rescinded the 2011 and the 2014 guidance that had come out from the Office for Civil Rights. She put some more in that were advisory only then, but did give some more due process rights to the accused, and has now spent the last few years going through a public notice and comment period that these regulations that came out on May 6th that are to be enforced on August 14th are now binding law with respect to this topic. So tried to make that as short as I could.
No, I think that was a great overview because, like you said, it is complicated. We could do a whole webinar just on the history of Title IX and who founded it and why. And but for me, you know, as a social scientist, as someone who's a former history teacher, and I think it's really important that people understand, well, where did these conversations even come from, right? Where did they start? How did they evolve? I think it's fascinating, even the history of affirmative consent in the United States really started in the 1980s with the kink community, moved into Antioch College in the 1990s, and then started to become more of a social conversation nationally, and then was adopted into our laws. So I think there's also that interesting kind of difference, right, between social movements and legal movements. Can they come together? How? And yes, the foreshadowing. I was creating the first sexual violence prevention and education program at the University of Houston in 2015 and 2016 when those first respondent cases were coming forward. And then OCR was really investigating schools like that one and many hundreds about, you know, well, what does this look like? What is fair? You know, what is due process? How do we not assume guilt but support survivors? So it's been a journey. Liz, can you tell us a little bit about your perspective as someone who was a student, saw these changes, is now a professional watching these changes happen? You know, what has been kind of the journey that you've seen with even just conversation? What are students saying? What are professionals saying? What's their kind of lens on what's happening?
Yeah, so a point that I always make with these types of conversations is even just the awareness and those conversations happening. I didn't notice them happening until after I had to, until after I became involved in this type of thing. So I noticed that it wasn't, you know, there are some student groups that are you know, taking part in taking action against this type of violence on their campus, but it wasn't really so out there. So that's when I really took on that role, at least on my small campus, just being an advocate and being a voice and reminding people that we can have a campus free of sexual violence. So I noticed that, you know, those conversations started sparking other conversations, and hopefully that type of thing is happening on more campuses. I'm noticing, but of course, I think it has to do with the work that I'm involved in and the fact that these are the organizations that I'm looking at and looking to work with. So I'm hoping that these conversations are happening on a larger scale. And um, we're also realizing that due to those guidelines, there was a lot of training compliance that came in. So that's really helpful with the education piece, is that, of course, we realized there has to be more guidelines with that in general, and the training should be ongoing, and the training shouldn't just be one time, and the training shouldn't be given by someone who potentially has the best interest of the school in mind as far as financially, and not the students as far as safety. So we realized that as educators, we have more opportunities to put our voice out there in that way, and to be giving these Title IX trainings and letting students know that they do have rights, informing them of where to go and who they can talk to. And that was some of the work that me and Dr. McGuire and I got to do together, is helping students even on at the Merchant Marine Academy, and students that are working on all different types of college campuses, and working specifically, as you said, with students who are on sports teams, and working specifically with athletes who hold a sense of power and privilege in these communities. So schools realizing that they need to utilize these trainings more has allowed us to be brought in more to give different perspectives on this topic, so that we can help people realize the best way to implement them, the best way to implement the trainings. And so we're luckily able to give some of those trainings and inform students of what they can do. And I think that's the most important piece. No one can say that they weren't given the information or the rights about what was going to happen. And I always make it very clear from that perspective of what will happen if a case does go forward for both people, because I saw what happened to the respondents in my case and the way that it affected and still clearly is affecting their lives. So I give that type of warning, and that's the education that I feel is important. That as long as we are making it transparent and we are letting people know exactly what's going to happen, then we do have to do that. And the standards, as you said, do have to be high. And we'll just let you know that they are very high. And if you would like to be on our campus and a part of our community, you will have to uphold these standards. So I think that those, those standards and those new guidelines put forth were really important. And I think the aspect of education. So I'm hoping that that part is not lost among these changes.
Definitely, definitely. So let's talk a little bit about both the training and the compliance piece in the quarantine COVID-19 environment. Because a lot of schools are saying, great, now we have new regulations, but what is that going to look like if we are doing mostly online classes for the foreseeable future? Some schools are projecting they'll come back in the fall, but some are unsure. So Dr. Felice, can you talk a little bit from your perspective on training and compliance if schools have to stay online primarily, or, and just the changes that might be coming long-term from the virus and what's put us through?
Sure. And I also want to just say to Liz that, first of all, I think it's really important that someone that's been a survivor steps forward and speaks. And I respect that. And I want you to know that that's one of the things that I think is really important for both complainants and respondents to hear about, because they don't always get that. And it also serves as a source, as a role model and a courageous role model for other women or men, but complainants, to come forward and know that they'll be okay and can make a difference. So I want to thank you for that. I also want to just say this is a difficult conversation because I represent both sides. And it is really, which is why it's unfortunate it's polarized, because I actually think there's a way that this can all be brought together in the middle, even with the current regulations. And I know we're going to talk about that later because you asked me to talk about compliance and training, but I think that's a really important message that I'd like to at least at some point address with you, Dr. McGuire, because I know we talked about that. And I think it's important for the audience to understand these don't have to be polarized, and they might actually work as they are if people do it the right way. But right now, my experience, because all my clients are college students or basically faculty or staff there. So certainly I'm aware of the pandemic and what's happening with that. Every school that I'm aware of has gone online or canceled classes. There's been a few people that tried to open, but basically that's what's happening. My experience with my own practice and talking to other people is that schools actually had to take a little hiatus in order to actually really deal with the pandemic and the transition, but are now resuming full force investigations that were underway. They're having hearings. Recent court ruling said that hearings on Zoom or some type of virtual platform are actually okay. There's a lot of disagreements about everything, but they're saying that that is okay. There are some credibility issues associated with being on a Zoom conference because you can't necessarily see somebody in person. But I think the court's ruling was because it's fair to both sides are on there, they're both going to have that. I think it's way better to do things in person if you can. There's confidentiality issues with going online because people can record this. There can be other people in the room because the rules talk about only having one person there. So there's some issues with respect to being online with these proceedings. But I'm curious about if schools all stay online for fall reopening and over the summer, exactly what's going to be the source of Title IX complaints, unless the conduct occurred before the pandemic. Not that there can't be cyber stalking and not that there can't be sharing of text and sexual material online, but the majority of the things actually, as we know, I think statistically show that they occur on campus. A lot of them occur around football games and parties and at fraternity parties. Not that that's saying that anybody's responsible for it, but a lot of the sexual misconduct occurs when people are together. And because of the pandemic, clearly that's going to not be the same because people aren't together if they're doing it online. Now, there might be more because domestic violence is on the rise with respect to the pandemic because people are left at home. So if there are students housed together, that could be actually more problematic. But with respect to training online for virtual platforms for Title IX for colleges and universities, they're going to actually have to, aside from being online, understand what these new rules and regulations mean with respect to Title IX processes. And I know we haven't gotten into the differences yet, but they're going to have to be trained on that and what that means. My personal experience is that most schools are well-intentioned when they do these processes, but they haven't been given good enough instruction. And the requirements are very, very high and rigorous and strenuous because there's actually, some college administrators call it and I apologize for one side, but academic capital punishment. Because many schools, if they find by a preponderance that somebody committed, sexual, I'm going to say penetration without consent, which could mean someone was incapacitated because they were too drunk or because they said no and they did it anyway, can be from the range of that to brutal sexual assault, which is clearly nobody thinks that should be dealt with in any way that's light at all. But when a lot of schools, when they make that finding, my experience will expel the respondent or give them a very long suspension without a continuum that includes education or healing for either side. So I think that schools, really need to be trained better anyway, and maybe they need to actually bring in trained professionals because the Clery Act, the Violence Against Women, and Title IX literally require as you know, Liz, right, require you to be trained in trauma and credibility analysis and relevance and, inconsistencies and what is sexual misconduct and what's preponderance. And these are things as a prosecutor for 10 years, it took me a long time to learn how to do that. You can't assess credibility easily without a lot of experience because it's not intuitive. So unless they're going to gradate the sanctions in a way that makes sense. And again, my pitch ultimately is going to be, there's a lot of potential here for restorative justice, where people can work in different process than a formal complaint, where they can actually empower both the complainant and the respondent. And since a lot of these are acquaintance, I'm going to call it acquaintance rape, but acquaintance sexual assault, instead of tearing apart the social fabric of either the complainant or the respondent, which often happens when these complaints come up, it can actually serve as a process to heal that and then creates ultimately culture change. So I think there's a lot of training before these regulations came in place that's needed, and a lot of training since that's needed, and since with the pandemic. But Liz, the other thing you said that I think is so important, because I've represented hundreds of kids across the country. Until it happens to you, the training doesn't sink in. You get so much training at college campuses, unless you know somebody it happened to, it just doesn't sink in. And you can train people and you can tell them and you can give them great transparency, but it really doesn't. I mean, that's my experience. They know it's out there and they get it, but they don't understand what it means. So whether it's a different type of training where you actually do a little bit more hands-on application, or videos of actual scenarios where people get it, or a movie, I'm going to date myself here, like Animal House, where there's so much sexual misconduct going on, everyone thinks it's funny, but you could show like each one of these would be violations, some way to bring it to the group, to the audience, to the 18 to 22-year-olds, so that they get it. Both sides, though. The other thing I just want to say, and then I will stop, is that for complainants, I don't think that the processes are set up to reinforce complainants, many times because of training, and there's a lot of opportunity for re-traumatization and for them not to actually be able to heal through this, where in a process they have control over. And I don't think complainants know that until they're in the middle of it, and it's not good. So I think there's a lot of training, again, that needs to be done on both sides.
Yeah,
Definitely. Yeah.
So I think that's so important that you pointed out, a lot of people have already had gaps in training, right? There's already been this foundation of lack of awareness of what trauma does neurobiologically, what trauma-informed care is, even in trauma-informed investigations, right? Like, what does that actually look like? It's a term people throw around, but they might not really know in application what that means. And credibility is so huge too. I just did a training on internal investigations of employees, and I talked about
in diversity and inclusion, we talk about unconscious and conscious bias and implicit bias. Why is that not part of investigative training? It should be. It absolutely should be. And then restorative justice, that we actually have an online certification coming out next month for restorative justice for professionals working in higher education to understand how can you take pieces of that and apply it to these cases, because it really does have to go beyond just reading regulations and saying, what boxes do I have to check to be compliant, right? To be on the right side of history, you have to dig deeper. I think Joe is with us now. Joe Vincent, can you hear us?
I can hear you, Laura. Now, whether or not you can hear me has been the trick for a little while. Am I coming through okay?
Yes, we can hear you now. Can you please give us a quick introduction of yourself and your work in Title IX, so our audience can learn what you are bringing to this conversation?
Yeah, of course. And my apologies again for I'm technologically inept, apparently. And so I've been struggling with this for about the past 30 minutes. Hello, everyone. Thanks for your patience. My name is Joe Vincent. I am a senior consultant at the Association of Title IX Administrators as part of the Income Group. I've been with T&G for 2 years now, performing the entire gamut of consulting type services, external investigations, training and certifications, policy development, policy audits, and all of the sort of things that go along, expert witness type stuff, final report reviews for investigators and coordinators and those types of things. Prior to that, I spent 5 years as a Title IX coordinator for A.T. Still University. It's a graduate health professionals institution that basically trains doctors and dentists and a number of allied health type professionals on a couple of big campuses, one in Missouri and one in Arizona. So lots of fun jurisdictional issues there as well, with programs and activities all over the place. I've spent a number of years in this field. I thoroughly enjoy this work, and this has been an interesting time to be a part of this kind of work, and I'm happy to be able to join this conversation.
Awesome. Well, thank you for being here. And I have had problems today with my webcam, so it must be something just that's going on today. But again, we're glad you're here. Can you speak to us quickly a little bit about the K-12 piece? We've been mostly talking about higher ed, but K-12 has now had to face a lot of new regulations as well. And that's something most parents and teachers will have little to no familiarity with. So what should they be aware of, and what briefly do some of those changes look like?
Yeah, isn't that interesting? It's funny that most of the foundational case law for Title IX is K-12 case law. If you look even at the decisions that are cited by the Department of Education in the new regulations, they're looking a lot at Gebser and at Davis, K-12 cases, right, that have formed sort of the foundation for what we understand baseline Title IX compliance to be. And yet over the last intervening 40 years, almost 50 years, the K-12 environments have not developed quite as quickly or as complexly, can that be a word, with the same level of complexity that higher education has been forced to. And so there are a number of surprises for K-12, the K-12 environment as it relates to the new regulations. Parents, I think, will be the least surprised. There has always been sort of an informal presumption that parents will serve in some kind of role as an advisor, or at least be subject to notice. The timing of that notice has always been kind of up in the air. Do we need to let parents know before we pull a student in for a conversation or for an interview? And the OCR with the new regulations has sort of memorialized the rights for parents to participate in the process, and even extended that a little further with their commentary that they expect that parents will be able to access the process on behalf of their student child. So there's now parent guardian rights that are recognized, where a parent or guardian can actually file a complaint and fully engage and participate in the process on behalf of their child student, which is an interesting new dynamic for K-12. In addition to that, many of the things that we've taught as best practices over the last 20 years or so that have now found their way into the regulations, and as Felice noted, now carry the force of law as it relates to stuff like developing an investigation report and making all relevant evidence available for the parties to review, and articulating a detailed outcome with a rationale that ties back to the relevant evidence. These are things that probably our K-12 colleagues have been accustomed to doing in a short form, with not providing a lot of extensive detail in terms of their determinations and the information that supports their determinations. And so I think that there's gonna be a learning curve there for K-12 administrators, both in identifying who those staff are gonna be to perform all of the separate roles that are identified by the regulations. And then also some of the documentary and record keeping requirements are gonna be new for that environment, because I think they've been accustomed to being able to resolve incidents with a little bit less paperwork and a little bit less burden to have to articulate all of the rationale and to demonstrate all of the evidence that's supporting the determination. Those are going to be new challenges. It's not ones that they can't overcome, but it's definitely going to be a shift for that environment, and maybe a little bit more of a shock to K-12 than it will be for higher ed, who's been kind of accustomed to trying to wriggle themselves into some sort of regulatory scheme for a while now.
Yeah, no, those are all really important points for people to be aware of. Kind of switching gears a little bit, combining those two realms. Liz, I wanted to ask you, there's been a lot of perception, and I honestly would say even a bit of fear mongering about that these regulations are the worst thing ever, and everyone should just, feel in fear for the fall and how this is going to be perceived by students and survivors. Tell us a little bit about your perspective on, again, your experience going through the process before these changes, and what schools, whether it's K-12 or higher ed, can do to be proactively supportive of survivors of trauma-informed, no matter what other pieces of compliance they have to now adjust to.
Yeah, so I think that everyone's bringing up a lot of great points about these changes and how they're going to affect students and how they're going to affect universities. So how these changes have how schools can legally follow these rules that, as Felice said, are now legally binding. There are ways that schools can consult with agencies like ours. There are ways that people can and universities can speak with survivors about how these processes have gone and how their policies can follow exactly what the federal guidelines require, but also be supportive of, as you said, all students on campus. So I think that, like we said, being of the survivor perspective and only knowing one case and only one experience that I've had, realizing that, as you said, the standards are so different criminally and on campus. And sometimes for survivors, and in my experience, Title IX was the only form of, and of course there's no justice in these cases, because even as you said, when it's acquaintance rape, thinking about who wins in a case if, like you said, I don't feel that things maybe, I think that sexual assault has so many consequences, and I think that it is the rape that is causing those consequences, and that all that social breakdown and the shame and the guilt and the picking sides, that has to do with the rape. I don't believe that has to do with how the investigation goes. So in that case, I think that having those investigations the way that they were able to go forward was the only way that I was able to, no matter who the people who did this to me were, even if they were acquaintances, The only way that I was able to feel safe and continue my education was through the Title IX process, which did implement that expulsion, persona non grata, because the school was able to find that, as you said, it was more likely than not that this type of thing had happened. In my experience, the perpetrators had told their coaches and had been creating a cover up right away. So for schools to be able to now not hold any liability if they were holding that for themselves. And fortunately, of course, we see how these cases often go, or I see, and as you said, in movies and things that show real life things. And that's what I love to do as well, is make my trainings as relevant as possible and help people to see, again, on both sides. In the high schools, I tell the boys that I think the consent education is the most important, that for everyone, of course. But if the boys are worried about someone accusing them of doing something without consent, then why don't we wrap our brains around exactly what consent is? And like you said, using complete relevant examples and trying to help them understand that if they do not get consent, this is what can happen. And you can be expelled from school. And 6 years later, you might still be fighting for your name to be cleared in some ways. So these are the things that, as we said, but also, like we said, getting that into their head is sometimes really hard, and we don't want people to have to learn from these experiences and from the traumatic thing. Some ways that I compare these things is when we're speaking with mental health and other types of issues that people may have. That are obviously different, but if we're talking about things like values, if someone commits a sexual assault, we have to realize that there are things we could have done before to help them. Just like if someone commits suicide, we wish that there were things we could have done to help them before they committed this act that was life changing for so many people. But sometimes they just do it, and we couldn't have helped them. So that, I think that addressing it from the way that we can tell people how serious this is, and we can tell them exactly how the processes may go if they choose to be involved, and hope that those types of things can create the and keep the strict guidelines that will keep campuses safe. Because as you said, it was really difficult, and with all the standards that have to be proven to get a case charged criminally, even if it was a brutal rape, is difficult, and to get a prosecutor to agree to take that case on. So sometimes Title IX is the outlet of justice for some individuals, whatever justice means to them. If it means that they were able to continue, or that their complainant was just held responsible in one way, just were informed in one way that yes, you did do something wrong that affected someone's life. So those were some of the things that I think definitely need to be upheld in these guidelines. And as you said, being able to follow the rules that are required, but upholding the values and standards can bring those two together without having to bring, I think, the uh, perpetrator and victim together, which is some of the new, and I'm not saying that that's what we're referring to, but in the new guidelines, that's what some of the things that they refer to is bringing the perpetrator and the victim together. And what we know about crimes of power and control is that it's really difficult to put someone who has had that power as a perpetrator and put them in a room where they are on equal playing field, equal ground. So because they never are. So that's what's really important, again, for people to understand. As you said, that the people who are making these decisions need to be aware of these things. In my experience, it was just regular people that at my second hearing, I saw some of the people who heard my first hearing. And, they are just regular individuals that are still on campus, still maybe have the best interests of the school in mind. So there are a lot of ways that, like you said, these things can be remedied while also still following those guidelines and doing what's best.
Yes, thank you. I think that you're absolutely right. It's it's really important for us to hear from people like yourself who can give more depth and context, right? Because you can read all the text in a book, on a page, in a training slide, but if we don't hear from individuals about their experiences, we can't create that multi-dimensional approach. We are almost out of time. We really need to do a part 2 in the future because there's a lot more to get to. But for today, I want to end on, I'm going to ask each of our panelists this. What can schools do to stay on the right side of history? Dr. Felice, we'll start with you. And after you answer that, if you can tell our audience how they can get in touch with you.
So I think it's the same with any type of action that's intended to treat people equally, that schools really need to look at the reason why these regulations are out there, the fundamental purposes, so that this conduct, and sexual misconduct goes from unwelcome touching of any kind all the way through sexual assault. It is a large continuum. And I know we talk about different things, but there's a lot of behavior included in here. But if schools understand that really what Title IX is requiring you to do is to investigate any problems, to remedy the harm that's been caused by them, and to make sure that that doesn't happen in the future. And that's really the intent of this. It doesn't mean that you have to kick somebody out of school because they violated one of your policies and procedures. From my perspective, what it means is you need to listen to the complainant. And what does the complainant need and want? Whether it's interim measures, informal processes, a formal process with a certain outcome. I've represented so many complainants that said, I don't want this person to be suspended or expelled. I want them to go through an educational training program, and I wouldn't even mind sitting with a trained person in restorative justice so that we can look at each other and they can understand the impact it had on me. Up till now, my experience is that doesn't happen. Schools feel that by OCR, they are required to investigate it and follow their procedures to the end. And that doesn't help the respondent or the complainant. So they need to listen to the complainant. They need to give fair and due process to both sides. They need to make sure both sides are heard and both sides feel, and you know this because I'm sure you will talk about this, Dr. McGuire and Liz, but procedural fairness is critical. It is a perception that you're treated fairly. There's a lot of research about, in criminal law mostly, a lot of juvenile law, that shows that if you feel like you're being treated fairly, regardless of the outcome, and I worked with a federal judge, and when he sentenced people to 30 years, when he looked in their eyes and he shook their hand at the end of it, and he said, I'm sorry, I hope that you use the things in prison to help you, and I hope that you come out well. It made a difference in their own sense of dignity and self-respect. And research shows when people feel like they're being treated procedurally fairly, they don't recidivate. They engage in more positive pro-social behavior. They don't appeal. They don't bring all these lawsuits. So it's really important that schools make sure that both sides are treated fairly. What that means, you can look at the policies and you can still do what's fair in there. But when someone's accused of something, in my perspective, and they're treated neutrally, feels terrible because you feel like you're a kid and you've been accused of something. So schools really need to put both sides at ease and say, we're supporting both of you. Some schools do this very well. Some schools don't because they're worried about looking like they're not neutral. There's a lot about the due process from Judge Gertner at the time and now the professor at Harvard with the 14 professors that signed the letter saying you need to give due process to the accused, many of whom were people that had been on the side of, or were feminists and were on the side of female complainants. Purpose about fairness here that schools need to understand. And complainants, who I represent, and I think it's important, and I say this respectfully, if the other side's treated fairly and the schools follow these in a way that is fair and does the right thing, which these processes can be done, you can do that within the new ones, then they're not going to have a basis to appeal. They're not going to have a basis to bring a lawsuit. There's not going to be the complainant living through years and years and years of all this emotional wear and tear. And it's important for both sides to be able to just go through this once if they need to. So I just want to say one last thing, and it's really important. I think one of the things that's taken most notice, particularly by complainants and some of my own clients, who said if these rules were in place, I would have never brought a complaint at this point because I don't want a hearing and I don't want to be, like you just described, Liz, on the same playing field. I would just say, you know, if there's a hearing, there are some ways that you might, when I've represented complainants, I've always wanted to cross-examine the respondent. I thought it would make a significant difference. It would make my client feel better and feel heard if her lawyer was talking to the respondent and asking questions the way she wanted to. But the regulations, as far as I've seen, and assuming that, you know, they'll be fleshed out, allow still for separate rooms on video. They're not going to be face-to-face. It's not a court of law. You don't get to be a lawyer and come in and hammer somebody. The panel or the hearing person gets to decide if the questions are relevant. There's a lot of protection. And I would just say, you know, the fear is that a lawyer comes in and actually does all the things you're not supposed to do in criminal court and plays on stereotypes. They're not going to allow them to do that. And if they do that, it'll probably not go well for the respondent. So there's a lot of internal controls about this that might actually permit somebody to a complainant to go through this as well as giving due process to the accused. And I can keep going, but I won't. I know we're running out of time. Again, I think Dr. McGuire, you asked me, you know, my website is duffylaw.com and all my information's on there, and anybody can call me. A lot of information, ask me either side questions about anything they'd like, and thank you again for this opportunity.
Thank you. Joe, can you tell us what you think schools can do to stay on the right side of history, and again, how people can get in touch with you?
Yeah, boy, what a scary question. Stay on the right side of history, right? I really appreciated Felice breaking down, and I've been on for most of this webinar. I only struggled with my audio for a few minutes. So I think I've heard everything we've discussed, and I felt like that discussion of the adjustment from the draft regs to the final regs that they made, particularly in the cross-examination portion, is an important one, particularly for survivors like Liz, who, when we were looking at the draft regs, you're right, we had a lot of trepidation about a well-trained attorney representing a respondent being allowed to subject a complainant to direct and maybe a little bit antagonistic or confrontational cross-examination. And that didn't look like a comfortable scenario. I do think they did some things in the final regs to mitigate that by making sure they were clear that not only are separate rooms okay, but they made it clear that technology can be enabled to allow everyone to appear in this sort of format, as opposed to even being physically proximate. And I really appreciated the new provision that allows the decision maker or the hearing chair to pre-screen all of those questions. It almost feels like a deposition format where the question is asked and then the hearing panel chair has an opportunity to say, no, that's not relevant, or I'm going to need you to explain to me why this question needs to be asked before it can go forward. I do think those are helpful. I'm still not thrilled with the cross-examination component. I'm not convinced that it's the greatest legal engine for discovering whatever the Baum decision articulated there, but I do appreciate how they mitigated it. If schools are going to stay on the right side of history, they will do so by, as Felice articulated, remaining committed to the central thrust of Title IX, prohibiting sex-based discrimination in their programs and activities. That does reach all sorts of physical misconduct. Let's not forget, we're also talking about a lot of verbalized harassing behavior and the interesting scenarios that are created when employees are subjected to these types of behaviors as well, right? Because Title IX is reaching those also and creating some interesting implications for employee-based processes at educational institutions. I think that there are two things that are going to remain central. The first is, as Felice noted, process is everything. Those of us that work in Title IX on campuses or for institutions, the process is our guide, right? Our commitment is not to stamp out all allegations of sex-based misconduct. Our commitment is to conducting our process in an appropriate way as it's written and published, so that we remain faithful to what we pledged to our students and employees that we would do, and that we do what we said we would do, right? Know your process, follow your process. It's the best lawsuit protection you have, is if you do what you say you're going to do. Uh, in addition to that, in addition to following our processes, right? One of the things that the regulations are going to make imperative for all of us is that we train a lot better than we have up to this point. The training provisions in the final regulations were much different than what we had seen in the drafts for the last 2 years in terms of specificity and the number of administrators that they reach and the subject matter and topics that they expect to see trained on. And I was so glad to see those training subjects articulated specifically, because they're right. If we're deploying investigators on behalf of our institution, they do need to know how to appropriately investigate and collect relevant evidence and communicate with the parties and present that evidence. We do need decision makers, and this is something that should be on every institution's radar right now. If we're going to pull one of our employees in and ask them to chair a hearing, we need to give them a robust suite of training on what it means to assess and analyze evidence, and to assess credibility appropriately and articulate a determination that's based on that evidence. And there are other training requirements outlined and articulated in the regs as well. I think we're going to have to focus a lot on training, and to Liz's point, so that we're not re-traumatizing or subjecting our complainants and respondents to additional trauma just by virtue of having to suffer through our process. And we can do that really well by making sure we're deploying well-trained and equipped individuals who are committed to following our processes. And then the last thing I'll say is sanctioning serious misconduct seriously. I appreciate the desire to employ restorative justice models and educational programmatic opportunities, and I do think there's a place for that. But I think when we're talking about, for instance, the situation that Liz described, there's not much worse that you can do under our sexual misconduct policy. And if that doesn't subject you to the most serious sanctions, then one sort of has to question, then what would? So I think our commitment to sanctioning serious misconduct has to remain within the scheme of deploying appropriately trained individuals and following our policies. And I think that's how we land in a good place, regardless of what regulations are released and what rules are imposed to guide or regulate our processes.
Awesome, thank you. And Liz, any final thoughts from you on this and how people can get in touch with you?
Yeah, I definitely agree with what Joe was saying, and how that kind of just comes back to the idea of fairness for all, right? That if we recognize that if we are starting on that level, if we sanction these offenses fairly. I also just wanted to point out the idea that we were talking about how most of these cases are acquaintance rape. And I think that we have to, everyone also has to be informed on the dynamics of these crimes. And if we understand that acquaintance rate means that you may know this person. We talked about them being part of your social group. So just understanding the shame and the guilt that goes along with sexual assault, and just to understand that no matter what happened to me and no matter how many people brutally assaulted me, I didn't want anything to happen to them. So I think that that's important to understand, that, you know, after you've been through something like that, you're dealing with a lot of different feelings, and feeling like, you know what, that whole idea of it's your fault that goes along with sexual assault. So when someone asks you, like, would you rather mediate this so that they can continue their life in a nice way, you might say yes in that moment, because even 6 years later, I almost said, should I just let my gang rapist go on with their life? Should I? And I just had to do it for survivors, is to continue that process. And I don't think that a lot of other people who, hearing my voice 6 years ago on the recordings compared to now, I don't think that a lot of survivors, not many survivors without intervention could get to the point that I'm at right now. And I think that many of them would allow their rapists to just receive different sanctions. So I think that, as we said, the training and the fairness, it comes down to every part of this conversation. So thank you for all of your inputs and insights. I so greatly appreciate it. And I can always be reached at here to serve at equityandagency.com.
Awesome. Thank you so much. Well, again, we appreciate the diverse range of perspectives and experiences that this conversation had today, and I feel like our audience will benefit from this. And hopefully we will do this again in the near future. So thank you all for your time today. Hope you have a wonderful rest of your week. And again, if anyone wants to get in touch with the National Center for Equity and Agency, it's equityandagency.com or here to serve at Equity and Agency. Have a great day, everyone. Thank you.
Thank you.
Thank you. Bye.
Bye.